The Supreme Court heard arguments Monday in a case over whether a school in Minnesota discriminated against a student with disabilities. Ava Tharp has a severe cognitive impairment and rare form of epilepsy, which causes her to have multiple seizures most mornings. Tharp's previous school in Kentucky had allowed her to start school in the afternoon and continue her lessons in the evening at home. However, her new school in a suburb of Minneapolis has refused to accommodate that schedule. And in 2021, her family sued the district for not providing their daughter with a full day of class. A state administrative judge sided with the Tharps, citing the Individuals with Disabilities Education Act, but the family has faced pushback in federal courts. CBS News legal contributor Jessica Levinson joins us now. She's a professor at Loyola Law School in Los Angeles. So, Jessica, what are the legal arguments at play here? What did you take away from Monday's arguments?
So the legal arguments are really what standard do plaintiffs, and that really means in these cases, students and their parents, need to pass? What's the threshold in order to prove these discrimination claims, typically in an education context under two specific federal statutes? This might sound very weedy, but the standard is really key in most cases, meaning, do you have to show something akin to intentional discrimination or bad faith? Or do you need to show something that's closer to a negligence plus type standard? That can often, as in this case, be the difference between recovering damages and getting something like a permanent injunction and not getting any damages at all. What was fascinating in this case is that these were some of the more tense oral arguments I think I've heard in recent history, because what the plaintiffs here, the parents and the students, have argued is that the school district is not just trying to say, use that higher standard of proof in the education context. They're trying to create, as Justice Barrett said in oral argument, a sea change, use that higher standard for all discrimination cases. That would make it more difficult for people to bring these cases, not just in the education context, but potentially everywhere, including the employment context.
Yeah, but pull on that thread a little bit more for me. So essentially, is the court deciding whether the plaintiffs need to show that the school district acted in bad faith or negligence? And how would that apply to some of the other larger implications of disability cases that could go before courts?
So, what we're looking at right now is that there are some lower courts, and this case is out of the Eighth Circuit, and the Eighth Circuit is one of these areas where students and parents have to show that higher standard, that bad faith standard, in order to succeed and get damages on discrimination claims. But the possibility, what happened in oral arguments, is the school district said, use that higher standard not just here, but we think that we shouldn't have a two-tiered approach. We think that higher standard should apply everywhere.
Hmm.
And that's where I think you saw the Supreme Court really pull back. I think I saw almost all of them pull back and say that would create a sea change. And I think that we're looking at a Supreme Court that's likely to side here with the parents and the student,
Hmm.
meaning the plaintiffs.
All right, Jessica Levinson, thank you so much.